Alrighty, guys, I'm here at the court and I'm just waiting for things to open up. But I'm the first one here, like I was last time. So, alrighty, it's a jury trial, so we'll see. Hopefully, we won't be here all day.
Me not having seen it, I didn't know how the plaintiff was getting to $20,000. Defendant or plaintiff you pointed out that there was an addendum or an addition to the petition. Both parties were, my recollection was, you would instruct us to provide each other, specific 194 disclosures starting with plaintiff. I've not, as I pointed out, plaintiff then went on to say, everything that's on file is my Rule 194 disclosure, which is, I don't think what you ordered us to do. And I a couple of times said, I'd appreciate it if you do, typically what happens, they send it to me, I then send it back to them.
Okay.
But
What are there surprise witnesses that you don't know about? Are there new documents?
None of that is what I'm about to bring up. So I'm left with going off her plaintiff's pleadings to figure out how she gets $20,000. And if you look at page 2 of that addendum to her petition, I believe we have a jurisdictional issue because, and I want to bring something else up at this time. Well, let's see. If you look at what she said way back when in her petition, May 23rd, 2025, I believe it's page 2, damages sought. It's actually A through G, wraps around to page 3. She says, this is what the plaintiff says are her damages. 8 months of rent, $9,600. Refund of application fee and admin fee. Security deposit, $3,000. Reimbursement for 1 year of renter's insurance, $320. Undefined amount in late fees and other charges applied despite landlord breach. Emotional distress damages of $5,000. Statutory penalties under Texas Property Code. And then wrapping over to the other page, wrongful eviction, $2,000. If you take just the numbers that plaintiff did provide and add them up, you get $19,920. Just taking late fees alone pushes this matter over $20,000. Furthermore, the defendant has plaintiff has.
Wait. She's not. She's asking for reimbursement of late fees. Okay, and that's listed in the total that got to $19,920.
No, she didn't list it in the total of how she got to $19,920, but she is requesting it. It is a damage.
Okay, let me visit with her for a minute.
Yes,
let's find out what are your damages that you're going to ask the jury.
May I point out one more thing that she filed with the court, though? She subsequently filed, via email, this document where the second to last paragraph says, this is, again, plaintiff's statement, not mine. I was seriously wronged by this company, and this is very serious. $20,000 is not life-changing money. I can sue them in civil court for $150,000 for sexual harassment alone, which is one of her claims in this case. She is saying I was sexually harassed. So by her own statements, she actually believes her damages are $150,000. And so with that,
Okay, let me visit with plaintiff. What are your damages that you're going to ask the jury for today?
Firstly, may I address the Rule 194?
Sure.
Okay, so a Rule 194, which you agreed to because he asked, because he came to court on March 5th claiming surprise, even though he was served like 12 papers. And those documents were in the original petition, literally in the portal. It says under original petition, there's like 12 documents. He was served, the private process server, it's stamped, there's proof he was served. So him claiming on March 5th that he had no idea that retaliation was part of it, that was wrong.
I hear you, but that's
now,
water under the bridge.
Now he says, so he asked for a Rule 194, which means if I have any surprises, anything that I haven't shared, then I share that. A Rule 194 does not mean that the whole process starts all over. I have to re-upload everything. If I have already provided enough for him to prepare, that's it. I don't have to resubmit the exact same information because there is no new information. Now, he claimed on March 5th that he had 2 witnesses.
I hear you.
I asked him.
So if he does raise claims of stuff he's never seen before or heard about, we'll deal with them as we get to them. But let's go through what your damages are, because I'm not too concerned about disclosures. We're going to trial, and the jury's going to decide all this. But what are your damages?
May I just mention one more thing in terms of the Rule 194? Sure. So he claimed he has 2 witnesses and people, and if she's one of them, I asked that you do not allow that because he never disclosed that to me. I did ask many times via email
Who's your witness?
It's
For
Angie
them to-
Barajas, the former property manager at the time she was evicted.
And I asked several times via email for your witnesses to be disclosed to me so that I can subpoena them. He did not.
Your Honor, she was asked the same thing, and she never disclosed them to me.
I never
For all
said
I
in
know,
March 5th in front of you that I had witnesses. I never said that.
Do
Everything
you
that
have
I'm
any witnesses besides yourself?
just me.
Okay.
He has everything that I
Right.
that I ever will talk about today
Okay.
has been on the portal.
Okay. All right. And how come she wasn't identified in disclosures?
Your Honor, the plaintiff never.
Right. But I'm asking you right now. Why? How come you, as a lawyer, understand what disclosures are?
Understood.
Why didn't you identify her in your disclosures?
She was the witness that would be here on behalf of the defendant.
She's a corporate rep,
She's the corporate rep.
although she's a former employee.
No, she's still an employee, just at a
She's
different property.
I got you. Okay.
That's the only.
Okay.
She's the person with the knowledge, and it's no surprise to the plaintiff.
Is she somebody you dealt with when you lived there?
She was one of the managers with Morgan Group,
Okay.
but there's no proof that she's a corporate rep because when I
Well,
was
corporate reps are.
Yeah, I spoke with
a
Shelley.
defendant can pick whoever they want.
yeah, I spoke with Shelley. That's who I was emailing when my emails were sent to corporate. They were sent to Shelley.
Okay.
So Angie, as far as what I know when I lived there, was just one of the employees, one of the managers at Morgan Group.
Okay. So
That was not
I'm
disclosed to
gonna
me.
allow her to testify, and you can bring up, to the extent she wasn't involved in issues and you're dealing with somebody else. Those are all things you can bring up.
So I asked for all original staff because they strategically removed all the original staff right before trial. I asked for all original staff contact information to be shared with me so I could subpoena them. Why didn't he provide that?
So, well, if you subpoenaed her, it would just make.
It's not just her. It's her. There's Taylor Roach. There's Cynthia. Those were the original staff.
Okay. What
Okay.
happened? Are they
There's
still with the company?
there's
Your Honor, I
Moriah.
don't- Are those
There is
individuals-
Moriah.
They're no longer employees.
Right.
They're no longer employees now.
So that's convenient because these are the people that were there when I was being sexually harassed. There's Moriah, who was directly involved in the sexual harassment, asking me if I was single, if I want to date another one of their employees called Phyllis. So Phyllis and Moriah disappeared right before trial, and everyone that was there and witnessed this is gone.
So I'll let you raise those arguments, and you can question their witness about any of those issues.
Okay.
But I'm going to allow her to testify.
Do I get to cross-examine her?
Oh yeah.
Perfect.
So let's finish these preliminary matters, and I'll go over how it all works.
Exactly.
Okay.
Your Honor, again, pursuant to the damages that she's disclosed, this is a matter of, and again, I'm just fine with, in one sense, trying it before this honorable court, but the damages are set by the plaintiff at
Right.
the time they file.
Let's go back to that. Can you walk me through what you plan to ask the jury for today in terms of damages? What's the total amount you're asking them for, and how do you break it down?
So as described in my document, I am asking for primarily my rent that I paid.
Which is
All the
what,
fees.
$9,600?
Yes, sir. All the fees that I paid to move in. My move-in date alone, I spent about $4,000 just to move in.
Okay.
So I paid for a year's worth of renter's insurance all at once. I paid for, there were some other things. It's been a while, but they know how much I paid for rent. They should know. And I want primarily my rent that I paid back.
Okay. So
And
what's
then-
the total you're going to ask the jury for?
I'm asking for the full amount because that's the least
The
that's
full amount being what?
which is $20,000, which is what I can get for small claims,
Okay.
because that is the minimum that I deserve considering what I went through at this property.
Uh-huh.
So
And what are your, let's talk about your hard damages. You got the $9,600 that I think you tagged as rent,
yes,
and $3,000 was what, move-in expenses?
yeah,
and
moving
application
expenses.
fees?
Yes, sir.
She said refund of application fee, admin fee, and
I
security.
can
deposit.
answer him.
Okay, go ahead.
Okay.
So, and then renter's insurance.
Yes, renter's insurance.
What else to get to your 20?
So renter's insurance. Also, the fact that Texas is 3 times damages state, I'm seeking damages for as much as I can get. But as stated here, there was a lot of distress that I went through because of these people, because of this corporation and how they do business and what they allow.
Mhm.
And so it's, It's documented here.
Okay,
And wrongful
so other
eviction,
than, the damages for distress and all that, any other hard out-of-pocket damages besides the 9,600, 3,000, and 320?
and the renter's insurance,
Yeah,
hard
I
out of
had that
pocket,
in there.
and of course my court fees, me coming here March 5th, them not being
Yeah,
ready.
if you prevail, court fees will be awarded to you.
Yeah.
Your court costs, as well as post-judgment interest if you prevail.
Yes, sir.
Okay, so any other out-of-pocket besides those three items? that we went over?
No.
Okay.
And sir, may I also address the email that he brought to you in terms of me saying that I could sue for a lot more. I mentioned that because when we were here March 5th, and not just that, it's his behavior prior to that, but March 5th, he was extremely condescending, joking with you, talking about how, oh, when someone sues for 20 grand, we raise our eyebrows, just like belittling the fact that I've been through a lot more than what I'm even asking for. So, you know, sexual harassment alone is not okay. And the way that, you know, the way that it was Taylor Roach before she mysteriously disappeared, she apologized for it, but him trying to act like 20 grand is more money than I've ever seen in my entire life, that's super condescending. So that's the reason why I put that in the email, was because number one, this guy knows nothing about me. So trying to be condescending about, oh, when they ask for 20 grand, we raise our eyebrows because, oh, that's so much money. I mean, like, to who? If I'm paying rent for a year, that doesn't cover
Okay,
it.
well, this won't be something unless you present it to the jury or he tries to present it to the jury.
He brought it up.
Well, have y'all exchanged exhibits?
I'm in the process of compiling my pile and giving
So
one.
why don't I give y'all a few minutes, because they'll be here, what, about 1:30?
They just assigned them, so.
But Your Honor,
Shut up.
So y'all exchange exhibits first. If there's no objections to each other's exhibits, they're all in.
right,
My suggestion to you is not to overwhelm the jury. Just pick out what you think you need to get to them. How many exhibits you think you have?
Exhibits as in pictures or proof?
No, I'm just anything you want to show the jury, whether it be a document, a text message, a picture.
Yes, sir. About maybe like 10.
Okay.
of the documents
If
that,
you could, do you have a list of them that you could give them
There-
or show them?
Yes, sir.
Do you have a copy of those 10?
I have it on the portal, and
Okay.
I've listed exactly what I'm going to show
Okay.
when I need it.
So
Maybe
you may
so.
want to go out, there's a computer by the elevator,
Okay.
and you can, or I don't think we can print from this portal.
She
But
can
you
go
can-
downstairs. That's
Yeah,
where she
or
can print.
one of the computers right here, they have printers.
Do they?
Yeah.
Okay.
So you can go there, pull up the case, print the documents you need.
Mhm.
But if it's something you want to hand the jury, you can't hand them the computer.
Right.
Occasionally, I'll make an exception and let people show them a picture on the phone and things like that. So what are the 10?
if they're the 10 documents that are on the system, I have them downloaded on my computer. She doesn't need to make a
Okay.
printout for me.
Excellent.
But
Are they already, were you going to offer them too?
no,
Okay.
no, Your Honor.
Okay.
But I would like to further discuss the question I have regarding the jurisdiction based upon the damage. She's planning to ask for all of these damages, Your Honor. And
It's not all of these damages.
Well, she's asking for 20,000.
No, but she's asking for more if you take into account late fees, if you can't take into account.
Sir, this
on-
court can only give 20,000, so I'm not sure why he's making it a big deal.
Well,
Talk about more.
It-
20,000
so
is the
what
max.
he's getting at is there is a body of law that says you can't back your damages in to fit the jurisdiction. So if your damages are 30,000, you can't say, well, I'm just going to cut them to 20, with some exception. But some of your damages, they're not hard damages. So your hard damages, you're out of pocket, we're looking at far less than jurisdictional limits. But if you want to ask the jury for 20, that's up to you.
Okay.
But Your Honor, she's saying she had 150 at one point. She said to this court, there's other issues we have with her pleadings. For instance, if we're going to go through to trial, not only should
Not if, we are.
Yeah, we're definitely going to try.
well, of course,
Yeah.
but once we go to trial, she should be prohibited from bringing up, the standard limine matters, such as you can't bring up before the jury. She can't argue in front of the jury that there's other witnesses who have not been brought here by either party that may have.
I'm going to allow her to bring up the fact that the people that she dealt with are no longer with the company.
Yeah,
But
that's
she
important.
can't bring up hearsay testimony.
It's not hearsay.
Well, we'll
They're not
deal,
here.
We'll deal with objections
They're
throughout
not here.
trial as we go. But
And-
let's get to the point. So I'm overruling your objections
All right.
on the jurisdiction limit. We're going forward. She's going to ask for 20 or less, and
But she
we've
has to
got an
prove her
itemization of
damages.
her out of
It's already proven.
Your Honor, may I ask her to quit?
No,
stepping
he
over me?
keeps-
Well,
he
actually,
keeps
I
int-
was the one talking.
he keeps
if y'all could
he keeps
both-
interrupting
if y'all
me.
could both just listen for a minute. Okay, so what other issues do we have left? Y'all are about to exchange exhibits?
I do have an issue with the fact that he's now trying to provide evidence or whatever he is that he's doing on the day of trial when my information's been here, public, in the portals.
So what evidence? Well, we haven't seen his documents yet, but what documents
There are documents
is
I
he
don't
offering
have.
that you have not seen before?
Apparently, according to him, almost everything, because he says he has a bunch of documents that he hasn't submitted to the court.
Let her finish. Okay.
There was no
She doesn't need to
instruction.
submit them before. Have you given them to her?
I'm going to give her a copy, Your Honor. But
Today, on
No,
trial
but has
day,
she seen them? Hold on. Has she seen them before today?
each and every one of the documents are documents either that she already would have had as a resident of the community
Would have
or
had.
would have received from another court with respect to the eviction
Okay.
or
why
communications.
weren't they included in your disclosure?
Your Honor, she didn't provide me.
I know
I
your
did.
complaints about her, but why didn't you do it?
Okay, Your Honor, I was under the understanding that the way Rule 194 operates is you get their disclosures, the defendant is then given time to respond to the disclosures and provide their own.
he got everything.
No, that's not the way it works. So let's see what your proposed exhibits are to the extent they were not produced or disclosed prior to today or some sort of unfair.
So he should be sanctioned. I asked for
Your argument
sanctions.
is she's familiar with it all, but if it's already in her documents or already something that was that she knows about, we can deal with it. But other than that, if it's the first time she's seen these documents, then
Okay.
Thank you.
Your Honor, most of them are like, for instance, a notice to vacate that she previously got from our office, a judgment that was rendered against her in an eviction.
in fact,
Which
on
would
that
not
point,
have.
hold on. You have a counterclaim on file.
Yes.
What is the basis of that counterclaim? Does it include back rent? Because I noticed that the judgment at Judge Carter's court awarded back rent, so that would be res judicata.
It would be accelerated rent after she moved out, and that sort of thing. Our
Right.
counterclaim.
Okay, what's the amount? Because you pled for $7,228.
That would be
First
the
they
amount-
sued for five. First they.
Hold on.
Okay.
That would be the amount that we pled for, Your Honor. It's calculated in the final account statement. But to be honest, the counterclaim, if she's allowed to adjust her damages based upon day of trial argument, we will do the same. But it's amount due under the lease that she previously signed.
Okay, and does it include back rent? Because
If-
back rent's already been awarded.
It would probably include, Your Honor, would include accelerated rent through,
Well, take a look at it and
Yes,
figure
yes,
out
Your Honor.
of the 7,228
Yes,
that you
Your Honor.
pled, if we take out back rent based on res judicata, what's left and how do you itemize that?
yes, Your Honor.
Okay. All right. So I'll let you get your exhibits together.
Certainly.
Let her see them. If she has objections, we'll deal with them.
Yes, Your Honor.
So once y'all are done with that, I'll explain to you how the jury selection process works.
Yes, sir.
And how trial works. You'll have a chance to make a short opening statement if
Okay.
you want. You don't have to. A couple minutes, 5 minutes, I would think would be enough
Yes, sir.
for each side. Each side can make an opening statement, and then you'll put your witnesses on. I take it
I don't have any
you're going to be
witnesses.
your witness.
Yes,
So
sir.
I'm not going to make you ask yourself questions. You can either sit in this witness chair or stand in front of the jury as long as you don't obstruct
Yes, sir.
counsel's view of the jury, and tell them what you want to tell them,
Okay.
and offer what exhibits you want to offer that support your case.
Okay.
And to the extent you need to print anything out, you'll want to go to the up
First
at the
floor?
elevator. There's 2 public use computers with printers attached, so
Okay.
you can just log in and pull up the documents you need.
Of this apartment community, 3800 Main. We're here today because Ms. Michaels has filed a lawsuit claiming various, she's got various gripes that she can go into. But they all sound in the nature of, for the most part, sound in the nature of the fact that she used to live in my client's apartment complex. And so defer to her in terms of what she tells you about. She feels she's been aggrieved. But in essence, we wouldn't be here today if my client agreed with her. This is a lawsuit. She has sued We have defended, we have answered, that sort of thing. So 6 of y'all will get to go into the box and decide who's right, who's wrong. This is just dollar amounts. This isn't an eviction today. But evictions do come up. And so oftentimes, we do, I'll just do this by show of hands, because how many of y'all have participated in a jury in any court, be it Harris County or elsewhere? By show of hands. All right, good number of you. First off, thank you again for your service to this county. Second off, what we're doing is, people who did the jury before, or even if you've seen the movie My Cousin Vinny, you remember that guy saying, what I'm about to do is or dire, which is a fancy blah, blah, blah. And it's like, well, okay, I mispronounced that phrase. It seems like every other day, and I've been practicing since 1997. But yeah, it's a way for us to learn more about y'all other than what's on this piece of paper. Before we ask 6 of you, I'll get this too. Before we ask 6 of y'all to sit in that box and basically sit in judgment, which goes to my first question. Those who participated in jury before, you may have had one of those attorneys that comes up and says, is it Naidu? Yes. Mr. Naidu, do blah, 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 and then they get you to answer one by one each question. That's a waste of time, in my opinion. I'd rather just ask you the question and you tell me yes or no, and if when we do this, as we do this, if there's something that I ask that you don't feel like answering in public, Judge Doodle's going to give us an opportunity to all of us come up to his bench and speak real quiet like. So don't worry about that. But my first question is, has anybody been involved in a landlord-tenant dispute, either as a landlord or a tenant? Yes, ma'am.
Hold your number up.
Yeah, if you can hold your number, if you're gonna speak, please.
Thank
let me
you,
know.
and I believe it's Ms. Matthews. Do you care to elaborate on your landlord-tenant dispute?
I was in college and I had a very bad landlord company who owned the complex, and I was trying to get out of my lease.
Got it.
And through it.
All right. And so, which goes to my overall question that we'll keep coming back to. Is anybody here today? Y'all responded to the summons. Thank you very much. But some of y'all may be here today thinking, I can't sit in judgment, for whatever reasons, be they spiritual, moral, ethical. Does anybody here feel like today that there's a reason, other than being able to approach a matter objectively and fairly, that they can't sit here in judgment today? It's okay if you can't. Okay, ma'am, that would be Michelle Regal.
Yeah, I just kind of went through this. I'm the family member of out in Gulfton Court. I didn't go through it. I'm the family of the owner of the condo, and we went through something similar. So I don't feel like I want, I'd be really all there to.
You don't think you can approach this matter fairly?
Yeah, I don't.
Because of, if anything, a bias towards the landlord.
Right, yeah.
All right. Your Honor, I know we're getting strikes, but also there's perimeter challenges, right?
You get.
I'm just asking.
Yeah.
Yep.
You can listen to the facts and be fair and set aside whatever your personal experience
hope
was, because those
so,
facts may be
but-
totally different.
Okay.
You haven't heard
okay,
any facts here today.
Okay.
Are you able to be objective and listen to the evidence and enter a fair verdict?
Mm-hmm.
Ma'am, were you raising your hand or were you scratching your elbow?
No, it's just right.
All right, so now we got that established. So does anybody here feel like when it comes to, and I'm kind of skirting through a lot of this, is anybody here a landlord right now? There we go. Number 3, Ms. Regal. Is anybody here a tenant presently right now with a dispute with their landlord? All right. And I guess I should point out, just like in number 7, Ms. Anthony, pretend we're at an auction. You know that old saying about, at an auction, make sure you don't scratch your ear because you may have just bought a car. And so, Ms. Trevino, I was thinking maybe you were giving me a signal, but okay. Okay, you were just taking your hair out. Has anybody worked for either of the parties? 3800 Main, which is managed by the Morgan Group. Has anybody here ever worked for the Morgan Group? Has anybody here ever had an issue with the company based out of Houston called the Morgan Group? All right. Anybody be surprised if such were the case, but nevertheless, let's ask it. Has anybody heard about this case? Stephanie Michelle's versus 3800 Main. I'm gonna ask it again, one more time. Has anybody sitting here today had a problem with their landlord, period? No. Oh, okay, gotcha. Ms. Matthews, but also I saw one back there. Is it, ma'am, you're, I believe you might be Stephanie
Yeah.
Whitson? What was your
Not
problem?
like a legal case, but I'm just trying to get out of my lease because I was verbal.
Got it. All righty. In this matter, what we have, what will be one of the bases for several claims is a written contract, a lease. Anybody sitting here today, and again, there's no judgment in any of these questions. We're just trying to figure out what you think, what you believe, because it goes into what you may do when you're up there in the jury box. Does anybody here feel like a contract constitutes an agreement that both sides, once they sign off on it, they're to live up to those obligations, no matter what those obligations are? Everybody comfortable with that knowledge, with that condition? Anybody here? Does anybody here feel like, well, you know the old saying, contracts are made to be broken, or a contract is just a prelude to further discussions? Does anybody else feel that? Does anybody feel that way? All right. This matter comes down to, there's a difference. I don't know if the juries that y'all served on, that served on a jury, or again, the movie My Cousin Benny, there's varying standards, thresholds of evidence in terms of proof, burden of proof. In this honorable court, in this matter, as a juror, the burden of proof is called, as opposed to beyond a reasonable doubt, or that sort of thing, we're talking preponderance of the evidence. And if you think of the blind lady justice holding the scales, it's a little bit of a tip one way or the other. And what I like to do, as an example, I guess I better ask this. I went to the University of Texas. Is anybody going to have a problem with that? Got any Aggies or Sooner? Oh dear. All right, let's see. Ms. Mullen, you got a problem with that? Go Cougs. I like the Cougs. So, and anybody else? Just a little. Okay, hey, it's fair. But you know, there have been games that football teams play where, and this is the reason I use the Longhorns, because the Longhorns they've gotten their share of wins, but they've also taken their share of losses. And Ms. Mullen, I'll point out that there was one game that I was a student at UT watching where Texas lost to U of H. Like, this was back in the run and shoot days with Jack Pardee. I think the score was like 50-3. That's beyond reasonable doubt. But there's been times where Texas played a game and it's won by a field goal. Does anybody have a problem with deciding this matter as if the score were 50-49? And if it's 50-49, just barely over one way or the other, you got to fine for that party. Does anybody have a problem with that notion, that it should be more than that? All right. But it goes back to the other thing. Is everybody here comfortable with the notion that if you claim something, and you claim this is what happened, you can't just say it. It's got to be proved. That's why they call it burden of proof. You have the burden of proof to prove what you said. Is everybody comfortable with that notion? And comfortable with the flip side of that coin, which is, if you haven't proven it more than they've disproven it, it's not up to, for instance, it's not up to this side to prove that this side didn't do it or something like that. It's up to this side to prove by a preponderance of the evidence that this side did this. That's why it's called burden of proof, as opposed to, say, burden on the other people to prove they're wrong. You have to prove you're right in any court. Is everybody comfortable with that? Because there will be things said. People are going to jump up. There's going to be objection, that sort of. You can't say that. That's not one side or the other trying to hide anything. That's one side or the other saying, wait a second, that's not proof. Proof isn't what somebody says somebody else said. If that were the case in Texas and America, we'd be in a lot more trouble. Proof is what the Honorable Stephen Doodle determines proof is, nothing else. And the Honorable Stephen Doodle will decide what comes in front of you. But if one side hasn't proven their case, is everybody comfortable with the notion of saying, you lose? Texas shows up for a football game against U of H, but they don't bring their cleats Do they get to call timeout? Let's go get our cleats? Nope. You come ready to prove. All right. Is there anyone here who looks at this as a matter of big business versus one person and thinks, I had one juror tell me one time, the business can always take the hit. But that's not the purpose of court. Is anybody here not comfortable with the notion of being able to look at the parties fairly and equally? It's okay if you are. If you're, look, these guys have to hire an attorney. You can't come into a courtroom and represent yourself if you're a company. And so, trust me when I say, our clients don't want to be here, but if they have to be here, they got to hire an attorney. Is anybody uncomfortable with the notion of looking at the parties equally? Even though one party is a company or an owner with a property and all that. Everybody comfortable with that notion? All right. Is anyone here, you may ultimately hear what's going on here and you think that's not fair. It's not this versus this is not fair. But fairness and justice and the law, sometimes people think they go this way. What's fair is what the Honorable Stephen Doodle determines is fair. You're here to apply the facts to the law, to the claims. Is everybody comfortable with that notion? And finally, will anybody be able, do they think they'll be unable to apply the law strictly without resorting to matters of sympathy or prejudice? All right. See, I didn't ask each one of y'all the same questions. That by the time I'm getting to Ms. Figueroa, she's like, yeah, I heard it, no, yes, whatever. All right. Thank you very much, ladies and gentlemen.
Thank you. Ms. Michaels, do you have any questions?
Not so much a question, just.
You can do follow-up. Go ahead.
Oh, okay. Hi.
Hi.
You guys look amazing. Thank you for coming. Well, they asked some really good questions, so I don't really have much to ask. I will just follow up on what he said about burden of proof and what he said about contracts. So most of you agree that a contract, if signed by both parties, should be upheld. Everyone agree? Okay, I agree too. Now, burden of proof. Sometimes a corporation might believe that because they're the defendant, the burden of proof is therefore on the plaintiff. But if we provide all the proof and it's on them to respond or to also provide what they have, since they're countersuing, and they don't provide their proof. Not a question. This is a fact, just a statement. If one side provides proof, the other side is supposed to provide their documentation, evidence, whatever they may have, witnesses, right? That, like you said, this is not about judging based on unfairness. This is about judging based on what is legally correct, what is right and what is wrong, based on the law, and based on how legal proceedings are supposed to go. So I want you to keep that in mind because we're going to be saying a lot of things today which are factual. And I like what he said about burden of proof because in a moment you're going to see just how much proof was provided and how much proof was not, because the other party sometimes believes they don't have to meet you halfway. So I'm not going to take up much of your time. Thank you so much for being here, and I can't wait to start.
Okay, parties, you've got your list. You'll each get 3 strikes. So what I need you to do is go through and just put a line through the people that you want to strike. And again, you get 3, and then sign your name and bring it to one of the clerks. And then we'll announce the 6 selected winners in a minute.
Your Honor, is the jury being excused while we do this, or can we go outside?
You can go outside. So, and we'll let those sit.
Yes, sir.
We'll give you about, what do you need, 5 minutes?
Yes, Your Honor.
Okay.
Can I check their numbers again?
Yeah, you've got the list, I think.
Okay.
Yeah.
Just- Oh, I'm sorry. Thank you so much.
So it's 1 through 9, left to right on the first row, 10 through 18 on the second.
I just want everyone. We have to try. Thank you.
You don't have to use your slides.
We don't have to, okay, yeah, I don't want to strike anybody.
Okay, what you gonna do?
Just sign it.
Sign it, date it.
Okay.
Date, place the.
Ninth. Thank you.
While we're waiting, let me ask you, did you finish on your exhibits? Do I have everything? Release and then some emails? Oh, it's got page 2. Oh, these are defendants. Have you seen these yet?
No.
Okay, he left you a copy on your table. Take a
Okay.
look and let me, after the signature, I'll take up any objection.
Yes, sir.
See what it says.
May I approach your honor?
Sure. Okay, all right, thank you. Here.
If I call your number, you are selected and you will be with us today. Shivan Naidu? Oh, I'm sorry, number 1, number 2,
Step up here, sir.
number 3, number 4, number 6, and number 9.
You call number 2?
Yes.
And you see.
All right, and you can sit anywhere.
1,
We
2,
actually have extra chairs.
3, 4, 6, and 9. Does anyone else, need a work excuse? And if you do,
I take
please
those
bring me
numbers,
your
please.
number.
Oh, okay.
If not,
All right.
Turn your numbers in and you're free.
I'll take it. Wherever you want to sit.
All right, thank y'all for your service. Appreciate you coming out today.
You need to work.
I'm not kidding, I baked my brains out on that.
I didn't ask.
Did you work? Does anyone else need to work?
Afraid I have.
You need a work excuse, ma'am? No. Leave your number. Thank you. You too.
So I think we have, I'm gonna, raise your right hand. You solemnly swear or affirm that you'll render a true verdict according to the law. Mr. Bone and Ms. Williams, I think we have a couple pretrial matters to try to deal with. I think we'll be able to make things go quicker if we deal with these first. So let's take a 5-minute bathroom